Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. FAPA remains a hot button topic in New York. It has long been understood and accepted that a permanent loss mitigation solution, such as a loan mod, resets the statute of limitations. Today, we'll explore if this remains the reality under FAPA or if a permanent loss mitigation solution that results in a voluntary discontinuance no longer resets the SOL. I'm Adam Friedman, managing partner at Friedman and Bartolo, and I'm joined today by Friedman and Bartolo Senior Associate Franklin Chu. Franklin is a giant in the New York default industry, and it's not just because he's 8 feet tall. He's one of the smartest guys I know, is one of the top default litigation attorneys in the state, and recently litigated this issue on 2 separate and distinct foreclosure matters. How's it going, Franklin?
Good, Adam. Thanks for having me here.
Very excited to have you on. You're a very busy guy. It's been very hard to pin you down. I don't know if you're 8 feet tall, but you are a giant. But seriously, I think even more importantly than that, you know your stuff. And in New York, especially in the New York default industry, you are one of the top guys. I'm really excited to have you on here. Let's focus on your most recent win. I think it's Athena Annuity v. Suggs. Do you want to walk us through the relevant facts of the case?
Yeah, sure, Adam. So in this case, this was a 2007 mortgage loan, and the defendant here defaulted on the loan in 2014 after a prior loan modification. On that default, the bank commenced a foreclosure action in 2017 and brought it to judgment. But the defendant then avoided foreclosure on the property by entering into a loan modification in 2019, which then also required a discontinuance of that action in 2020. The defendant then continued to make loan payments on the mortgage until he defaulted again in 2022. So as a result, the bank then filed the current foreclosure action in 2024. So defendant argued in this case that the prior foreclosure action accrued the statute of limitations in 2017, so that the statute of limitations expired in 2023, even notwithstanding the fact that he modified the loan in 2019.
How can you argue that? Like, how could somebody in good faith say, a loan was accelerated, it was settled with a permanent mod, meaning my default was cured, not a new loan, but it functions that way, right? Like, how can someone argue that credibly?
Yeah, you are absolutely correct. The status of the law to this point has always been that if you modify the loan and you reinstate it, the statute of limitations runs anew. Unfortunately, due to the recent enactment of FAPA and the amendments to various statutes, the defense bar has been trying to manipulate the language of FAPA and its amendments to mitigate that principle.
So just not to go on a tangent here, but I just want to flesh this out further. So let's say the law was that a loan mod does not start the SOL anew, right? So let's take these facts. 2017, a foreclosure actions commenced, right? Let's say they continued paying the loan mod for 7 years. We're saying in that scenario, if the law is SOL does not restart with a permanent loan mod, after 7 years, if the borrower then stops paying, they just have no loan.
That's correct.
Wouldn't you never be able to give a borrower a loan mod?
Correct. And in fact, other judges have cited that in their decisions that this would place a huge burden on both the banks as well as borrowers by discouraging them from entering into any loan modifications.
So what did the court do here?
So in this instance, the court ruled in our favor and decided that the 2019 loan modification did indeed reset the statute of limitations despite the amendments to FAPA. In the moving papers, the defendant argued that FAPA's amendment to CPLR 213, paragraph 4, as well as 3217E, dictated that the loan modification did not reset the statute of limitations. Here, the court disagreed and determined that FAPA's amendment to CPLR 203H, which governs the statute of limitations for mortgage foreclosure actions, specifically excluded in its application, quote unquote, unless expressly prescribed by statute. And the court determined that the existence of General Obligations Law 17-107 is in fact such a statute. And that statute states that when part payment of an obligation which would otherwise be unenforceable under the statute of limitations is made, the statute will run afresh beginning with the date of that payment, provided it may be inferred from the payment that an intention arose therefrom to honor the entire obligation to which it relates. So ultimately, the court determined that notwithstanding any of these amendments to FAPA, the law regarding the renewal of the statute of limitations upon loan modification still applies.
So Franklin, we have a lot of non-attorneys that might tune in, and your explanation was great, but it's detailed. There's a lot of moving pieces. So just so we're clear for our audience, did this ruling hold that if a default is cured via loan mod, the SOL resets, or is it that if a default is cured via something that necessitates a discontinuance of the case, the SOL resets? Does it have to be a loan mod? Like, what if it was a reinstatement?
In this case, we were dealing strictly with the loan mod, but the decision can be applied either instance where it's either a reinstatement or a loan mod.
The reason why I'm asking is not everybody calls the settlement document the same thing. It could be a loan mod. It could be something else that just cures the default. And we're saying like this can be used if the default is cured to say SOL is resetting.
Well, under General Obligation 17-107, as long as it's a reaffirmation of the debt and an express promise by defendant to pay the mortgage debt, then it ostensibly would be applicable.
Would it be advisable to change anything within like a standard permanent loan mod? Like, do you think that a permanent loan mod satisfies that, or we need to add something post-FAPA?
It's probably advisable to include express language to counter any type of argument like this.
I think what's interesting is this seems so obvious, right? If you cure a default, the SOL resets. Like, it seems so obvious, but we're also gathering that there's going to be a lot of FAPA arguments being raised by the defense bar. Can we use this case to say, if you cure a default, the SOL resets, or is the defense bar going to argue it's like more minute? Like if this specific language is in the loan mod, or if it's specifically called a loan mod, we satisfy it, or are there like other ways to attack it? You know what I'm saying?
Well, I mean, because General Obligations Law 17-107 requires an express promise by defendant to pay the mortgage debt, it probably behooves us to have an explicit statement in the reinstatement agreement, the settlement agreement, or the loan modification agreement that specifically states that the defendant promises to pay the mortgage.
So do you think this will go up on appeal? If so, what do you think would happen?
Well, at this point, I'm not sure that this particular defendant will be taking an appeal of this decision, but more than likely, given that it's a FAPA-related issue, it will probably be raised in appeal at some point in time, especially given the interrelation of the statutes at play. But I believe that based upon the sound reasoning of the court, based upon the law, I would expect the appellate division to uphold the decision.
All right. To recap, there's no question that FAPA has significantly impacted the New York default industry. But it's important to fully understand this impact as certain cases and situations remain unaffected. Thanks for joining Franklin Chu and I on the Weekly Friedman, your source for the most essential information in the default industry. Looking forward to seeing you next time, and thanks for tuning in.